Welcome to Amicus, a law review with Jim Santelle, Civic Media's weekly review and discussion of some of the most significant news stories in the areas of law, government, courts, and the aspiration for justice. And now, here's your host, Jim Santelle.
This is Amicus on the broadcast stations of Civic Media. My name is Jim Santelle. I am your host this hour and next hour. This, of course, our weekly weekend review of all things related to the administration of justice, to rule of law issues, and the interaction of those broad topics into and out of our government. I thank you, as always, for spending some portion of your weekend in communication with me, discussion with me, in review with me and my producer, Max, as we take you on a survey this week and also in future weeks, as in past weeks, of a great number of news items, civics issues, and governmental developments that are important to understanding the world around us, including our nation and the operation of the rule of law. As always, you can be a part of that discussion, that survey, that engagement by calling in. That number is 855-752-4842. You can also drop a comment into our chat box. Always here as Civic Media, interested in your, especially your inquiries and your questions about what are often some of the complicated but nonetheless understandable and accessible understandings of that world of rule of law. This past week, has been extraordinary by any measure, and we are going to be spending the lion's share, most of our first hour, a portion of our second hour as well, talking about the developments, both in court and out court, with respect to the prosecutions of three of the president's self-proclaimed by the president, his adversaries. Their names are James Comey, the former director of the FBI, Letitia James, the present attorney general of the state of New York, and John Bolton, the former national security advisor for the Trump administration in the first term. All of them have been indicted by grand juries in two different districts, all of them on the list of this president as political adversaries. He has called for their indictments, their charges. He's described them all as being guilty as hell, and he has been frustrated when prior prosecutors that he himself has appointed, others inside the Department of Justice, have failed upon determination that there is no cause to indict, have failed to do that, have not done what the president wants to have done. And instead, he has placed in the position of at least one of those U.S. attorney positions, that is in Eastern Virginia, his own selected attorney who returned indictments against James Comey and Letitia James. The third indictment against John Bolton, that one proceeding in the District of Maryland, being prosecuted by a veteran prosecutor there. A different kind of case for all sorts of reasons related to the developments there, even the substance of that particular prosecution. And we're going to update you in this segment, this edition of Amicus, a law review, about the week's developments in each one of those cases. The Comey case, the James case, the Bolton case, a huge amount of information revealed about the status of those cases, again, both in court and outside of court just this past week, and some revelations that are nothing short of shocking, offensive, concerning, dismaying, and ultimately the kinds of disclosures about the conduct of the Department of Justice in prosecuting at least two of these cases that should warrant the outright dismissal of them based upon the identification of prosecutorial misconduct. And yes, indeed, the conduct of our president to begin all of this in demanding the prosecutions of Comey and James. We'll talk about all three of those prosecutions and explain here on this broadcast the reasons why they are not merely in jeopardy presently. These are cases that are now so flawed by the procedural gaffes and missteps, whether intentional or not, that justice demands their dismissal. We'll talk about all of that in the first hour, again, inviting you to be a part of that discussion. In addition, in the second hour of Amicus, a law review, we're going to return to some other issues that we have spoken about in the past, and that is the work of federal district court judge James Boasberg in attempting still to get a hold of, to disclose, and to identify information related to that event way back in March of this year, in which planes brought about 238 migrants from this nation to El Salvador without due process. He has indicated this past week what he is going to do to resume his review of exactly what happened there, the contemptuous behavior of this administration in violation of the law. We'll talk about what Judge James Boasberg has announced just this past week about what's going to happen in December. And then in another district court, this one in Maryland, we're going to chat once again about what Judge Paula Zinnes, likewise a frequent mention of her on this broadcast, in connection with her continuing administration of the case involving Kilmar Abrego Garcia. You remember him well. He was among those 238 people unlawfully, without due process, deported to El Salvador, back in the United States now, right now on detention in Pennsylvania, waiting two things. One is a criminal prosecution against him. That is scheduled for Tennessee in January. And more recently now, hearings in front of Judge Paula Zinnes to try to figure out what to do in connection with the immigration, the civil side of the cases brought by this administration against Kilmar Abrego Garcia. Information shared inaccurately by the government this past week with Paula Zinnes about the possibility of sending Mr. Abrego Garcia to Costa Rica. We'll talk about why that's important, why that might be a partial resolution of at least the immigration status on this. And we'll talk once again about the frustration, like Judge Boasberg, that Judge Zinnes has when it comes to trying to get a handle on the mess that has become that prosecution, civil as well, in her court. Finally, we're going to talk about yet another issue that has plagued our nation in this time when the rule of law is in our national important focus, and that is what is going on in Chicago. What is happening with respect to the interests of a federal district court judge in ensuring that law enforcement there on the streets of Chicago follow the law, do what the Constitution is required to do, and we'll talk specifically about her issuance just this past week of a huge document in which she has described the reasons for her entering a preliminary injunction preventing some of that law enforcement from engaging in the illegal, unconstitutional acts in which they have been engaging. She documents them in a 223-page opus. We'll talk all about that as well. And then we're also going to make mention of something else that happened with respect to law enforcement and the National Guard deployed in Washington, D.C., the work of another judge, that judge, Gia Cobb. Judge Cobb finding that the presence of about 2,000 National Guard troops there in the District of Columbia was most likely unlawful, pausing that order until mid-December, but finding that the deployment of those National Guard troops, about which we have reported, about which we have seen so very much in recent weeks, has been unlawful. We'll talk about all of that here on Amicus, a law review, and as always, inviting your discussion with me, your engagement with me, with your questions, your comments, your observations, especially your inquiries. As always, Amicus, a law review, focusing upon our mission, which is premised upon the name of the broadcast, Ami, the Latin for friend, Amicus Curiae, the Latin, the legal language for friend of the court, hoping through the information provided in this broadcast to be a friend of the community in explaining what has happened at a time in America where, for good or for bad, mostly for good, the American people need necessarily to understand an awful lot about what goes on in the courts, inside the tribunals of our nation, federal, state, local tribunals, needs to know an awful lot about how grand juries work, which we're going to focus a lot upon in this upcoming broadcast, needs to understand the rule of law, generally the administration of justice, and the separation of powers, the checks and balances that animate our system, when all of that is so important to understanding what is and is not going on in America. It is the mission of this broadcast to provide often some very detailed, some very specific, sometimes very law school-like information about your understanding, to assist your understanding of these important issues. That's our mission. And that mission much on display in this hour and next hour, as well as we jump in to these major news stories of just this past week. Some of them from the very start here, some of them shocking in connection with the behavior of your United States Department of Justice. We'll get to that in just a moment. Let's begin once again by providing some factual basis, much of which you know already. Let's talk about the basis upon which James Comey and Letitia James and John Bolton, three separate criminal prosecutions, two of them pending in Eastern Virginia, one of them pending in the District of Maryland. Why? Because it is alleged that the federal criminal conduct described in the indictments against them took place in those particular jurisdictions. That's called venue. That's the basis upon which a grand jury finds, if at all, that there is a basis to charge an individual, in this case, three different individuals, for three sets of discrete actions. None of these is related by virtue of the underlying substance of what these three have allegedly done, but they all are all connected. Again, first and foremost, by virtue of what the president has said, what he directed the attorney general to do in a number of ways, including especially a very important communication made its way into the public domain on September 20th, directing the attorney general to indict individuals who have been on his so-called enemies list. And indeed, when that did not happen with respect to James Comey and Letitia James, when a Trump appointed an interim United States attorney named Eric Siebert looked at the basis for any prosecution of Letitia James and James Comey for months, involving also colleagues in the U.S. Attorney's Office in Eastern Virginia, involving FBI agents and other investigators, looking at whether there was any basis at all to charge them, again, on different substantive grounds, came to the determination that there was no there there. That there was no basis, in fact, even to seek an indictment in front of the grand jury, and therefore closed out those cases. We know what happened in the wake of that within hours, certainly within a day, the president reacting very badly and appointing a new interim United States attorney. Her name, Lindsay Halligan. She's been much in the news, much a part of our broadcast here. And yes, indeed, she dutifully does, within days of arriving in that office as a second interim United States attorney. Keep that in mind. She does, in fact, get what the president wants, which is indictments from James Comey and Letitia James, even as her colleague in Maryland properly is pursuing in front of the grand jury charges against John Bolton. All of that is going to be the subject of our discussion here on Amicus, a law review, as we continue here on the broadcast stations of Civic Media. name is Jim Santelle. This is Amicus, a law review on the broadcast stations of Civic Media, devoting all of our first and perhaps a portion of our second hour in this broadcast to these prosecutions of James Comey and Letitia James and John Bolton, updating you on the major things that have happened just this past week. Lots of things from the pens of federal district court judges and magistrates, events happening in the federal courts of our land. Let's review, first of all, the specific allegations against each one of these three, again, in different cases, premised upon different factual scenarios. First of all, James Comey, a grand jury, again, Eastern Virginia, that's Alexandria, right across the Potomac River from Washington, D.C., issuing two charges, namely one count of making a false statement and one count of obstruction of a congressional proceeding. Both of those premised allegedly upon some testimony before a Senate committee in September of 2020 given by James Comey. He happens to be in his home in the Alexandria area because why? Because during that period of time, COVID was preventing in chambers and in Congress reviews and proceedings. Therefore, he is in his home in Eastern Virginia, and members of the Senate questioning him there in Capitol Hill. And according to the indictment against James Comey, these two counts, these statements that he makes, a specific one in particular in response to a question almost certainly from Senator Ted Cruz, is about whether or not he directed a subordinate to engage with a media representative in connection with an investigation. An awful lot of lack of clarity on exactly what that was about. And indeed, it has caused, in the course of the disclosure of discovery, some concerns about exactly what the nature of that charge is. And that will certainly be a part of the continuing prosecution and defense of that case. What about Letitia James? Again, same district, Eastern Virginia, different circumstances. She is charged also in a two-count indictment, this one accusing her. She is the present New York Attorney General, but this has to do with her engaging in bank fraud or mortgage fraud, defrauding two financial institutions and making false statements to them in connection with her purchase of what, again, in 2020, of a residence in Norfolk, Virginia, again, the Eastern District of Virginia, specifically alleging that she used the home as a rental property instead of a secondary residence, as was contemplated by the bank documents. Again, a mortgage fraud, a bank fraud case about misrepresentations that she may have made in connection with her getting that loan. Again, both of those, as you're identifying here, happening in 2020. The reason for the expeditious nature of the movement by the prosecutor on both of these cases is that the statute of limitations, different crimes, different facts, different charges, about to run out in September of 2020. Thus, the reason for the president's push immediately for the prosecution of these two, the presentation of cases before the grand jury, which is precisely what Lindsay Halligan, the replacement U.S. attorney, did before the grand jury. And finally, you've got the charges, not in Eastern Virginia, against John Bolton. These happen in the District of Maryland, and that happens to be where his home is located. An 18-count indictment, again, in the District of Maryland, accusing the former National Security Advisor of using personal email and a messaging app to share with some family members, some people in his own family, about 1,000 pages of some diary notes, many of them that were classified according to the indictment against him, containing some national security secrets, all of them recounting information that he got in 2018, 2019, when he was serving as that national security advisor. According to the indictment, much of those sharings prefaced by words like the intelligence briefer said, "This I got from the Situation Room," suggesting in this 16-page charging document that John Bolton knew that he was disclosing, again, to family members information that was classified, part of national security secrets. All three of these have denied the substantive charges against them. All of them say this is wrong. And I should hasten to add, as we always do on this broadcast, that each one of them is presumed innocent until proven guilty. That attends to every single defendant in connection with a federal and a state criminal charge against them. Presumption of innocence attends them until such time, if ever, as a jury finds them guilty unanimously beyond a reasonable doubt. Those are the standards that have to be met. Each one of them has not only denied the underlying substance, but also raised the issue, which we're going to get to in this portion of our broadcast, that each one of these is not premised, in fact, upon justice, but in fact is preceded by these directives from the president to indict, and therefore is the product of what's called vindictive prosecution, an attempt by the president to get his political enemies, selective prosecution, identification of these defendants, of these individuals, when others who have done similar things go unprosecuted. That's selective prosecution. It is all wrapped up into one, each one of these maintaining, because they have been on the receiving end of these very vocal criticisms from our president, suggesting, maintaining, moving the courts to dismiss these cases on the basis that the motive for bringing them is not legitimate. It's not justice-based. Instead, it is prompted by this movement, this request, this demand by the president, acted on by the attorney general, acted on by United States attorneys to prosecute people who would not otherwise be prosecuted. That's their claim. And those are pending in all three cases. This past week, once again, some major developments in writing coming out of the judges and the magistrate judges, coming out of proceedings in those district courts that change the gravity and change the focus and change the very substance of these cases as they go forward. When we come back, more about the specifics in each one of these as Amicus, a law review, continues. This is Amicus, a law review on the broadcast stations of Civic Media. My name is Jim Santelle. I'm your host for the remainder of this hour and next hour as well, where we do a deep dive, a close examination of what has happened in these major criminal prosecutions of James Comey and Letitia James and John Bolton. Let's begin with the big one, not to minimize the significance of the others, but this is where the bombshell news came out from federal district courts, magistrate judges, district court judges just this past week. Let me once again set the stage for three different things, three different events, three different pronouncements by federal judges in just the past 10 days or so ago. We hinted at one of them in our broadcast late last week, and it has resurfaced in connection with other proceedings of just this week. How has James Comey, how has Letitia James, how has John Bolton defended in part against each of the cases against them, again, alleging vindictive prosecution? That is, that the prosecutions of them are not the products of a substantive reason to believe that they have committed crimes, but rather instead prompted by the encouragement, the urging, the directive, the order of the president to indict each one of those. That's one portion of the defense, which has almost taken backstage in the past week or so to some other nightmarish things that have surfaced in the record of these proceedings, which we will now get to. The second portion of the challenge relates to the authority of the United States Attorney, again, Lindsay Halligan, appointed by the president after the first interim appointment resigns or is fired. Her appointment, whether that is legal, and if in fact it is not, whether it is not supported by the statutory foundation for this, then she's got no authority to present any of these cases, any cases at all in the Eastern District of Virginia, including those against James and Comey. But the question is, if she has no authority, then what is the status of the indictments? And the answer would be they must be dismissed. And so you may recall that last week we touched briefly upon this significant hearing that was conducted by a judge named Cameron McGowan Curry. She is from South Carolina. She's brought in to the district because of some appropriate observance of ethical issues. Don't want any federal district judges there in Eastern Virginia who are involved in the administration of cases coming out of that U.S. Attorney's Office to be presiding over matters that relate to the internal structure and the leadership of that office. And so Judge Curry brought in from South Carolina to avoid those ethical problems. That's done appropriately. And she has a hearing, as you may recall, in which she is addressing one of these threshold issues having to do with whether or not Lindsay Halligan, the new interim U.S. attorney, was properly appointed. Some background on all of this. The ways in which U.S. attorneys are appointed, nominated, get their jobs, not intuitive, although they're fundamentally constitutional. You may think, well, gee, isn't this one of those things where the president nominates, the Senate confirms, and that's where U.S. attorneys come from after that process is completed? And you would be right about that. U.S. Marshals also fall in that category. The other ones we talk about a lot are federal judges. Again, nominations by a president, review and confirmation, if at all, by the Senate Judiciary Committee, by the full Senate, and only after that, appointment by the president to these positions. The difference between federal judges and U.S. attorneys and marshals is federal judges across the board, lifetime appointments. U.S. attorneys, no lifetime appointments. They stay for the tenure of the president who appoints them, or if they leave early, thus prompting this kind of thing, the president, through the attorney general, does have some mechanism for appointing an interim United States attorney until the Senate can review another nominee. In fact, in my not too recent history, I was an interim United States attorney. I was appointed by an attorney general named Janet Reno for about a year. in the Eastern District of Wisconsin, in between administrations and in between presidentially appointed United States attorneys. When my term, if you will, as an interim U.S. attorney concluded with the confirmation of a presidentially nominated U.S. attorney, I then became once again an assistant United States attorney. And that happens with great frequency around the country when there are these vacancies. Here, what happened is that the president nominated and placed in this position Eric Siebert. He was the original interim United States attorney. He reviewed these cases involving James Comey, Letitia James, as I said, and found that there was no basis upon which to do it, to proceed with indictments, charges against them. He is summarily either dismissed or he resigns, depending upon what news report you choose to believe. And he is then replaced by Lindsay Halligan, again through the Attorney General, who places Lindsay Halligan in that same spot in an interim posture. And that's what gives the question all of its meaning and all of its force. The question is, can you appoint in these interim non-Senate confirmed positions U.S. attorneys, basically stacking up 120-day periods of time? And an awful lot of people look at these and say, no, you cannot. In fact, in my situation, I was there for a year, more than 120 days. And then under this arcane system, the local federal judiciary makes a decision about whether or not I or an interim appointed U.S. attorney continues. They did that in my case. And then my appointment continued under a court appointment. It was only much later, under another administration, the Obama administration, that I was presidentially appointed and confirmed by the Senate. This is not an intuitive process at all. The point of this, getting back to the issues in Eastern Virginia, is whether or not the stacking of these two 120-day term appointments of U.S. attorneys is legal. And Judge Curry entertains that in a hearing of last week, the week before this past week, and she entertains argument on both sides of this issue. The defense argues that this is a fundamental defect and that the U.S. attorney, Halligan, has no capacity whatsoever to appear in front of the grand jury to authorize any indictments, including that involving James Comey. And by the way, Letitia James, this happens to be one of the peculiar situations where both of these cases, because they raise exactly the same issue, are consolidated for argument in front of the judge, Judge Curry. And so the question is whether or not these stackings of these interim appointments is legal. Again, defense attorneys say they are not. If anything, the next appointment had to come from the court or from the president nominating either Ms. Halligan or someone else to that position for Senate confirmation. At the heart, once again, is whether this 120-day limit imposed for interim U.S. attorneys is truly a limit, if it has meaning or not. Defense attorneys arguing that following the limit, an interim appointee must be confirmed by the Senate or have their appointment extended by the judges of the district in which they serve. That's the process. And the administration, of course, takes the opposite view. They say, no, we can do this. And in fact, perhaps recognizing some problems with this appointment, the Attorney General also confers upon Lindsay Halligan the role of special attorney, capital S, capital A, and says it's another reason why she's got my authority to do what she is doing. And that's the issue that the judge was entertaining over a week ago in argument, those two opposing views. The judge significantly has indicated that she is going to resolve this, whether or not there is authorization of the U.S. attorney to return to appear in front of this grand jury and secure these two indictments with any authority. If she finds, presumably, that there is no authority, the indictments presumably need to be dismissed absent authority, as do presumably any other indictments that were issued during the term of this interim United States attorney. The judge has indicated she's going to decide this before Thanksgiving, which is just, of course, a few days away. So next week, we will look for Judge Curry to give us an opinion on this, a decisive order on this. Presumably, if it goes badly for the government, for the Department of Justice, they will take that up on appeal to the appeals court. Who knows? Maybe it goes to the Supreme Court. But big news coming up next week if Judge Curry issues her opinion. Then the other reason why this opinion is so important is because of a singular question that Judge Curry asked of the parties at the end of this proceeding of well over a week ago. She hearkened back to another federal district court judge. Her name is Eileen Cannon. Remember her? She was the judge in Florida who determined in the end that Jack Smith, remember that name? He was the special prosecutor properly appointed by virtue of a congressional enactment, some legislation that created special counsel, special prosecutors. She had before her the question of whether Jack Smith, not nominated by the president, in that case by Joe Biden, not confirmed by the Senate, nonetheless had the authority to prosecute, to secure indictments against Donald Trump. That case in particular focusing upon the Mar-a-Lago documents. Remember all of this? And in the end, Eileen Cannon, although there were many other things pending in front of her at the time, before that case ever went to trial, Eileen Cannon determined that Jack Smith had no authority to prosecute the case, no authority to get the indictment in the first place, alleging that Donald Trump had inappropriately taken from the White House, retained, perhaps used, bandied about classified information. Judge Eileen Cannon had determined that the case had to be dismissed because there was lack of authority in Jack Smith, the prosecutor, to do what he was doing. And so the case was dismissed. Jack Smith took it up to the appeals court, and time basically lapsed in such a way that the case ultimately was dismissed by the government upon the entrance into the White House of Donald Trump and the memorandum that prohibits the prosecution of a sitting president while that president is in office. That's a lot, I know. But the reason for it being very important in connection with this case is because at the end of the hearing of a little bit over a week ago in front of the judge, she looked at the parties. She looked in particular at counsel for the government, the counsel for the Department of Justice and itself, and said, can you tell me whether or not Judge Cannon was wrong in dismissing the case against Donald Trump? And there were gasps in the courtroom by every report of people who were there, because the judge had just identified a huge inconsistency. She was basically asking, who is wrong about this? Was Judge Cannon wrong to dismiss the case because, in fact, Jack Smith had the authorization to proceed? In which case, arguably, the present interim U.S. attorney, Lindsay Halligan, would also have the authority to proceed. Or was Eileen Cannon right in doing so, dismissing that case involving Donald Trump? If Eileen Cannon was right in that instance, then the same principle would necessarily require that Lindsay Halligan be found without capacity to prosecute this case. Therefore, this case, like the Mar-a-Lago case, also needs to be dismissed. It is a stunning question, and one that underscores the nature of the problem, and also one to which there is not a clear answer, at least as of now. Indeed, it poses a huge problem for the government in terms of identifying exactly what authority is that Lindsay Halligan has to proceed. And when we come back, we'll talk about the other, arguably more stunning things that happened in connection with the James Comey prosecution as Amicus, a law review, continues. My name is Jim Santelle. This is Amicus, a law review, talking all about these major problems, major, huge, catastrophic problems in the prosecutions of James Comey and Letitia James. Just reviewing the initial problem which is the authorization of the U.S. attorney, the interim U.S. attorney, to do this at all, and whether or not you can stack 120-day interim appointments. The law seems to suggest you cannot. You need to either go to the judges of the district to get the appointment of a U.S. attorney for authorization purposes, or you need to go to the United States Senate. The president can, of course, nominate and get a confirmation, if at all, from the Senate. Any one of those mechanisms. The allegation is that this is not the way to do it. And if, in fact, Judge Cameron McGowan Curry finds that Lindsay Halligan does not have the authorization to pursue these indictments, all the things that have been done under her are therefore discredited and illegal, including the prosecutions of these two cases. The authorization issue applies to both the Comey and the James indictments because they come out of the same district. Those two indicted within days of each other under the signature, under the approval, the authorization, if at all, of the same interim United States attorney. There is a second and much larger issue that has broken this past week that also is in addition to the vindictive prosecution, the selective prosecution arguments that still loom large, perhaps at the top of the list. But there is more related to the grand jury process itself. What is a grand jury? A grand jury, again, this group of 23 people. There is a grand jury in every single one of the 93 federal districts around the country, every single state, every single territory of the United States of America. Grand juries, why? Because it's in our Constitution that you cannot be indicted, you cannot be charged except for presentation to and a return by the grand jury of an indictment. The notion, James Madison writing that into our Constitution, that you want a jury, in this case a grand jury of peers, to decide whether or not charges should issue. You don't want the king, you don't want, frankly, you don't want an attorney general, you don't want a president, you don't want a United States attorney to be the one making those determinations. Footnote is, of course, that there are some statutory ways, some limited ways, in case a grand jury is not immediately available for a U.S. attorney to issue a criminal complaint. That is proper, that is legal, but it also is subject to subsequent approval, if you will, by further action of a grand jury that ultimately has to indict. And so that fundamental notion about review by a grand jury and the sanctity of that process in our system, indictment and charges in the federal system only by virtue of 23 members of a grand jury. They sit in districts, again, around the country. They typically meet 1, 2, 3, 4 times a month, not every day, and they decide whether or not the evidence in front of them is sufficient to return charges, whether the proposed indictment, the proposed charges of the U.S. attorney are sufficiently established by evidence presented in front of them. The standard is probable cause, not proof beyond a reasonable doubt. That's the trial jury standard that follows the grand jury process. These are people who determine as a threshold matter, is there enough to indict? And I would offer to you, in anticipation of the argument that I'm going to be making in the second hour here of our broadcast, that this process is so fundamentally important that any flaws in it must be fatal to any prosecution, including these, especially the James Comey prosecution. Why do I enter down that road? And that is because just this past week, in the wake of the hearing by the judge on authorization, that was a public proceeding, other proceedings of recent times prompt a magistrate judge, again, in the same district, but he is there on a regular basis. He's not from another district. His name is William Fitzpatrick, and he is presented with some of the grand jury transcripts from the time of the presentation of the James Comey evidence to the grand jury sitting in Eastern Virginia that ultimately does return this 2-count indictment. Now, you may remember well that indictment was messy at best, We know from the records, not only disclosed by Magistrate Judge Fitzpatrick, but from the previous taking judge, that is the magistrate judge who took the indictment after it was returned by the grand jury, that there was mess. Were there 1, 2, 3 counts, and the magistrate judge not certain of exactly what she had in front of her. In fact, we now have some clarity because of the mess, the cumbersome, the bungling nature of this in front of the grand jury, and in particular, some things that the United States attorney herself, appearing in front of the grand jury, said to the grand jury that also tend to compromise the entire prosecution. In a remarkable rebuke of this process, of the interim U.S. attorney, Ms. Halligan, William Fitzpatrick, who is, again, the magistrate judge there looking at grand jury transcripts, issues a 24-page ruling. He says, among other things, that he is ordering the government, this extraordinary relief, to provide Mr. Comey's lawyers with all the grand jury information, everything said in front of the grand jury, evidentiary presentations presumably made by an FBI agent, things that Lindsay Halligan said to the grand jury, all of that recorded presumably by a court reporter there, all of that now directed to be delivered to the defense attorneys. Why? Because the magistrate looking at these materials initially, a first blush cut, if you will, of these documents says there's a high likelihood that there is government misconduct in the presentation of this case in front of the grand jury. And he orders the production of all of the information so the defense counsel can parse through it and determine what may be there and what more may be there in addition to what the magistrate judge has identified. He says, among other things, that Lindsay Halligan, in front of the grand jury at the time that she is presenting this case, made at least 2 fundamental and highly prejudicial misstatements of law to them. Stunning, shocking. And when we come back, I'll tell you what those were, and I'll tell you what the result of them should be as we continue our discussion of this monumental thing that has happened in America here on Amicus, a law review.
Welcome to Amicus, a law review with Jim Santelle, Civic Media's weekly review and discussion of some of the most significant news stories in the areas of law, government, courts, and the aspiration for justice. And now, here's your host, Jim Santelle.
This is the second hour of our weekly weekend review of all things related to the rule of law, the administration of justice, and yes, government. We are focusing a lot upon the government of the United States of America in this edition of Amicus, a law review. My name is Jim Santelle, because the work, the activities, the actions of your government officials, much on display or at least disclosed this past week by a federal magistrate judge in the Eastern District of Virginia, in connection with this prosecution of James Comey for lying, for making false statements to the Congress of the United States of America. The issue is the manner, the means, the mechanisms by which that indictment was gotten before this group. This grand jury, these 23 people convened together under our Constitution, under the Federal Criminal Code as well, Rule 6, other provisions establishing the grand jury and the sacrosanct nature of what they do in determining whether there is a basis upon which to do the single most important thing that a government can do to individuals, residents and citizens alike, and that is charge you with a crime and potentially deprive you of your liberty, potentially put you in custody, depriving you of your capacity to be at liberty. Of course, the most significant thing that a government can do under the Eighth Amendment is to execute you upon a finding of guilt. That is, of course, the most dramatic one. But short of just that, the most significant thing that a government can do, it's not taxes. It's not requiring that you abide by certain regulations and rules for products and even driving at a safe speed on the roads. It is this. And that's why this is so incredibly important, not just for James Comey or Letitia James, even James Bolton, but for every single American. This is the process upon which our criminal system rests. Absent cracks in it, it is a good system. It has integrity. It's got a process that is known and identified as long as the government behaves. And what happened this past week is that a federal magistrate judge found, in connection with the James Comey prosecution, that there may well have been committed by the government prosecutorial misconduct, government misconduct, grand jury abuse in obtaining this indictment quickly, very quickly, sloppily also, in front of the grand jury against James Comey. What did William Fitzpatrick say in his 24-page ruling? He said that Ms. Halligan, in her personal, individual, she was there, may have delivered two fundamental, highly prejudicial misstatements of the law, telling the grand jury about what the law is when in fact it is not that. What in particular did she say? According to the magistrate judge, they are shocking. He notes, based upon his initial review of the grand jury transcripts, that Lindsay Halligan, the interim United States attorney, told the grand jury, deciding on whether or not there was probable cause to indict in this case, that the defendant proposed in the indictment, James Comey, did not have the right under the Fifth Amendment to avoid testifying at his own trial, basically saying that the Fifth Amendment of the Constitution of the United States of America does not apply, implicitly suggesting that, yes, we can compel James Comey at his criminal trial to testify about anything, including information that may or may not be favorable to him. She said that the Fifth Amendment would not apply to James Comey, preventing him from testifying at his own trial, basically suggesting that this fundamental constitutional right afforded every single American, whether you are the subject of grand jury proceedings, in civil proceedings not involving the criminal practice, you have a Fifth Amendment right. It can be waived. There are certain circumstances under which you can be compelled to testify if indeed you've entered into government's arrangements to waive your right, and with understandings full and complete There can be some immunity grants given, but not here. And Lindsay Halligan misstated the law to a grand jury that's deciding and is dependent upon a proper misstatement of the law, deciding on whether or not to return a grand jury indictment against a human being, a resident, a citizen of the United States of America. That in itself is sufficient to find that this indictment needs to be dismissed. That's grand jury abuse. That's government misconduct. But there's more. Judge Fitzpatrick also says that during the course of the same proceeding, she also told grand jurors something else, also perhaps suggesting that maybe we don't have enough in front of you right now to get this indictment. But she said stunningly, again, this is Judge Fitzpatrick recounting what the grand jury transcripts say. She told grand jurors that they did not have to rely solely on the record before them. You can look at other things. She said, you don't have to rely on the record before you to return an indictment against James Comey, but instead you can be assured that the government has more evidence, perhaps better evidence, and will present that at trial. That's what the principal chief federal law enforcement officer of the Eastern District of Wisconsin, Eastern District of Virginia, what Lindsay Halligan told the federal grand jury that was charged with responsibility to decide about the indictment of a resident, a citizen of the United States of America. Both of them flat out misstatements of the law, suggesting that perhaps there is not a substantive basis upon which to indict, but don't worry, we'll have more at trial. Anyone who has been a member of a petit jury, that is the trial jury, even those of you who may have been on grand juries know that that's not the law. That yes, indeed, you've got to indict or not based exclusively on the things that are presented to you. And if you were told that there's more stuff out there, more evidence out there, but we're not sharing it with you now, we'll get better evidence and just rely upon the confidence in the government. That's only a misstatement of law that is misleading the grand jury. That's prosecutorial misconduct. A second reason to dismiss this case. The judge also went on to say that Lindsay Halligan appears to have botched her efforts to pare down this 3-count indictment that she had originally sought against Comey after the grand juries had somehow, in this mess of a process, rejected one of those charges. We've talked about that before. You recall well that the magistrate judge who received the ultimate indictment here had 2 documents in front of her and wasn't clear on which one it was that the grand jury had in fact returned. He noted, that is the magistrate judge, that the grand jury transcripts he received from her did not appear to contain her presentation of the second 2-charge indictment to the grand jury, leaving the record incomplete. So in other words, even the things that he's gotten, although they indicate that she messed this up, are not clear on exactly how the second indictment was gotten. If, however, a second presentation was never made, the judge said, we are now in uncharted legal territory. That's the magistrate judge describing what he has seen up to now in all of this. He wrote that the indictment returned in open court was not the same charging document presented to and deliberated upon by the grand jury. Stunning. Either way, the judge concluded, this unusual series of events, still not fully explained by the prosecutor's declaration, calls into question the presumption of regularity. We've talked about that idea before, that the government processes inside the criminal procedure mechanisms, there's a presumption that they're regular until this administration, until this Department of Justice undermines that. The judge that says that we are now calling into question that presumption of regularity generally associated with grand jury proceedings, and now provides another genuine issue the defense may raise to challenge the manner in which the government obtained the indictment. Grand jury abuse, government misconduct is what he is talking about. And it's on the basis of what he has seen up to this point that the magistrate judge then orders that the government do something extraordinary. And that is produce all of the grand jury materials, testimony of the singular FBI agent who appeared, testimony, statements given by the United States attorney herself. What did she say? What more did she say to the grand jury? It's not there. It's not complete, which is also telling. The magistrate judge plainly upset about the fact that even the disclosures made to him to this point are not complete. And he directs the government to produce everything so the defense can take a look at all of it to see exactly what the U.S. attorney, the interim U.S. attorney, said, did not say to the grand jury in her instructions to the grand jury. So fundamentally important. You know, as a trial jury member, that at the end of any trial, what happens? The judge gives you instructions on the law, tells you what the law is, and says, here is what the law is, so that you can make a determination about what the facts as applied to the law necessarily prompt in terms of a verdict. That's what happens also in front of a grand jury. The grand jury decides facts. The government gives that grand jury what the law is. And if the law is misstated as it is here, if the case is bungled as it is here, there is only one remedy, and that is dismissal of the charges, because the process has been so tainted, as it unmistakably already has been along the way. The magistrate judge isn't done. He says, oh, by the way, there's one more thing. There's another potential problem with the government's grand jury presentation. He questions whether the FBI agent, who's the one substantive agent, the one substantive witness who's appearing in front of the grand jury to provide testimony, the sole witness to have testified, may have inadvertently disclosed information that should not have been revealed. I'm giving you information that's unlawful to provide to you because of the protections of the attorney-client privilege. Again, sacrosanct in our process. Violation of the attorney-client privilege, arguably, once again, identified by the magistrate judge as another mistake, another goof, another mess, another reason to believe that the grand jury presentation was fatally flawed. And it's in the wake of all of that that he orders the disclosure of everything to the defense so that they can take a look at the issue plainly not done. The government promptly, right before it's required to produce this, does what? Goes to the presiding judge. And his name is Michael Nachmanoff, Nachmanoff. We've talked about him before. He is the one who is presiding over the actual trial in the Comey case. Judge Nachmanoff, who is, again, responsible for reviewing all the things coming up from the magistrate judge, then has a hearing this past week. He doesn't issue an opinion, as does the magistrate judge, but he has a hearing. And on its face, that hearing is supposed to be about this issue related to vindictive prosecution, selective prosecution. Instead, it turns into a wide-ranging examination of everything the government has done, including the vindictive prosecution aspects of this. It is, again, another stunning event just this past week that underscores how bankrupt this process has been. The judge peppering the attorneys for the government with a series of questions that are underscoring the rampant irregularities in the case, including stunningly, now even more, as suggested by the magistrate judge, that the full grand jury did not see the final indictment that it approved, that it was supposed to have approved. And indeed, during the course of the examination of this hearing, during the course of this back and forth between the government lawyers and government and attorneys for the defense and the judge, it becomes clear, at least for the moment, that the United States attorney never presented the full and corrected indictment to the grand jury. When we come back, I'll tell you why that is so problematic and tell you what Judge Nachmanoff said in the midst of all of this here on Amicus, a law review. Jim Santelle. This is Amicus, a law review. We are spending the lion's share of our time in this weekend broadcast talking about the outrageous conduct of your government in presenting an indictment to a grand jury, misstating the law, fumbling the mechanism by which the grand jury indictment was returned, and raising other issues about the legitimacy of these prosecutions against James Comey and Letitia James. Let's get back to exactly what Judge Nachmanoff, who is the district court judge in Eastern Virginia, who's presiding over this entire case in which James Comey is charged with having lied to Congress back in 2020. Judge Nachmanoff, again, in the wake of the 24-page opinion days earlier by the magistrate judge finding all of these irregularities, finding that Lindsay Halligan herself had misstated the law, told the grand jury things that are not true in securing the indictment against James Comey. Judge Nachmanoff picks up on that. He begins to talk about a wide range of problems that he sees, including going back to the start, Donald Trump's statements about wanting James Comey to be indicted, and this notion that there were earlier decisions, indeed there were, by career members of the U.S. Attorney's Office finding that there's no basis to do any of this. All of that a part of this, again, stunningly extraordinary hearing in front of Judge Nachmanoff just this past week. At one point, one of the other attorneys, again, in the courtroom with the U.S. Attorney, Ms. Halligan, his name is Tyler Lemons, acknowledged that someone in the Deputy Attorney General's office across the river at Main Justice had instructed him not to discuss with the judge. Don't tell the judge whether his predecessors had or had not written a memorandum laying out their reasons for not bringing charges, because that was privileged information. Don't tell the judge anything about that. That's what somebody in the Deputy Attorney General's office told an attorney who's now appearing in front of this federal district court judge. In the end, under withering questions from the district court judge, Tyler Lemons, apparently unnerved by all of this, confesses that the earlier prosecutors, those who had taken a look at this case, had previously handled the case and had, in fact, written a memorandum declining this prosecution, saying there's no basis for going ahead. That's one of the less significant findings and outcomes of this hearing, believe it or not. He decided not to issue a ruling, that is, the judge, at the time of the hearing, based upon the claims of vindictive prosecution. There may be more of those coming up, but he appeared to be leaning in that direction. And given the revelations previously and during the course of this hearing, there are now more reasons to throw out these charges, and Judge Nachmanoff may, in fact, do just that. But the most surprising development in the midst of all of this hearing of 90 minutes, tense courtroom colloquy back and forth, very, very troubling on so many grounds, is that Ms. Halligan, through Mr. Lemons and herself, acknowledged that she never showed the revised indictment in this case, the one that was ultimately used to charge James Comey, to all the grand jurors. Now, as I indicate, grand jurors are required to vote on indictments to approve grand jury indictments themselves. Lemons tells the judge that only the foreperson formally approved the second charging document, and that's an action that could not only cripple this, but order its dismissal. When Lindsay Halligan first went to the grand jury, this is part of the record in this case, she had initially sought a 3-count indictment against Comey, and after the grand jurors, again, had rejected one of those charges, she apparently went back and tried to repair this, put this back together. She did not represent the case with only 2 counts, but simply had the original indictment redrafted to reflect the failure of a third. We're omitting the 3rd count, but according to the representations made by her and the other attorney in front of the judge, never went back to the full grand jury and said, this is now the indictment, that with your concurrence, your vote, which is mandated, this is the indictment that will go forward. Instead, we'll simply have the foreperson sign off on the new document. Nachmanoff, the judge, according to everybody who was in the courtroom, seems stunned, shocked by all these events. And he asked the interim U.S. attorney, Lindsay Halligan, to stand up. asked her to respond to some questions. He asked her whether the entire grand jury had the opportunity to see the second indictment. Straightforward. And she told him that it had not. The grand jury did not see the full indictment returned charging James Comey with federal criminal offenses. The judge thanked her and told her to sit down. The attorney, needless to say, for James Comey, identified this as yet another reason to dismiss the case. It appears, again, although he did not rule on this, that Judge Nachmanoff was horrified by what he is hearing, not only in his courtroom, but also premised upon the findings of the magistrate judge that are also before him. A judge has promised to issue opinions at some point on all of this, including whether or not all this has to be disclosed to the defense, almost certainly will be, to identify any other problems in this grand jury process, including ones related to the attempt to reconstruct a grand jury indictment after the grand jury had gotten rid of a third count. The rule on that in grand jury proceedings is if the grand jury indictment, the proposed indictment, is changed in some way, you go back and you represent the entire indictment over again. That's how it is done. Why? Because that's the integrity that we contemplate when it comes to grand jury proceedings. Why is this so important? Again, it's because this is the process. This is the constitutional mechanism established by our founding fathers by which the only way by which people can be indicted in America is through this process, a grand jury of their peers understanding what the law is, relying necessarily upon the accuracy, the presumption of regularity from the government attorneys, and looking at and finally approving, if at all, the full indictment before them. That did not happen here. And so Judge Nachmanoff has an awful lot before him, including vindictive prosecution, including these gaffes, these errors, these misconduct events before the grand jury. When we come back, we'll talk more about that and how they implicate the cases involving Letitia James and also news involving James Bolton. All of that when we come back here on Amicus, a law review. This is Amicus, a law review on the broadcast stations of Civic Media. We are reviewing and providing some commentary on the outrageous behavior of the United States Department of Justice in securing at least one, maybe two, of these indictments against some of the president's adversaries. Their names, James Comey, Letitia James, and John Bolton, revealing what the federal district court judge was outraged about during the course of a hearing of just this past week, that it may well be that the full grand jury never looked at the final indictment presented to it, also coming in the wake of these material, substantive misstatements of law by the U.S. attorney to the grand jury, bungling of the mechanisms through which a final document is presented, also suggesting that some information provided by the FBI special agent may have been in violation of fundamental evidentiary prohibitions. There is a lot going on here. We know, however, in the wake of this disaster for the prosecution, for the government, in the wake of these hearings and of the judge's review of this, that late this past week, the Department of Justice, recognizing the disaster that this is, filed something called a notice correcting the record, filed in the court, telling the judge that, in fact, what we said in court before about the document never being presented to a grand jury, that was probably in error. Telling the judge now that a transcript of the grand jury proceedings will show that the full panel did see the final version of the indictment, and take a look at that. That's what your government did in the wake of this absolute catastrophe in this case, and arguably other cases of recent days. Needless to say, the latest filing prompts defense counsels to reject them. The new position contradicts the defendants' attorneys say numerous other representations made in court, the government has made to the court, and it rests on an erroneous overreading of an ambiguous exchange between the grand jury foreperson and the magistrate judge. We don't know what all that means, but it will become clear as these grand jury transcripts, again, in their complete nature, are disclosed to the defense. This is catastrophic. This is cataclysmic, not only for the case involving James Comey, and as to him, it is just more human tragedy, as we also talk about routinely. Every single criminal prosecution in America partakes of that. Why? Because of the serious nature. The stakes are so very high. And also now to the grand jury system generally. You have taken a system upon which we've relied in terms of integrity and confidence and belief that what they will do has some merit to it. It is not proof beyond a reasonable doubt. It is simply the mechanism by which cases get to a trial jury that ultimately determines guilt or innocence. But it is so fundamental to our system that this administration's decision, apparently, as the magistrate judge said, either recklessly, either intentionally, either simply without an appreciation, of what they were doing, did this. Whatever the reason, this is not America. This is not the way this process is designed to proceed. And now we've got even more confusion prompted by this Department of Justice. The Attorney General of the United States of America, this U.S. attorney, needs to dismiss this case now and bring it to its end. The errors, the misconduct, the government failures in this case, the abuse are so rampant, even on what we have seen up to this point, that there is no other result that can come. And look for Judge Nachmanoff to do just that. He's got a lot in front of him. He's got the vindictive prosecution piece, supported by an awful lot of indication that, yes, indeed, that's exactly what's going on here. He now has this grand jury abuse matter. And yes, in front of the other judge, we've got the issue of authorization. All three of those should be wrapped up into one order, dismissing this case, bringing it to its end, and telling this administration, this is not the way you behave, not in America, not for the past 236 years since we've had a grand jury system. The Letitia James case, also subject to at least one, if not more, of those same motions. She is likewise raising this very clear and substantially supported notion that the President of the United States of America is engaging in vindictive prosecutions of her with respect to the things that he has said about her. The disputes that the two of them had, undeniably in the public domain in both directions, but based upon selective prosecution, vindictive prosecution. Others could have been prosecuted, are not. She is, because of the president's animus against her, this very telling, this smoking gun decision by the president to direct the attorney general in mid-September to indict these people now, frustrated when it does not happen promptly enough. That is enough for any federal district court judge to find that these cases need to be dismissed on an improper motive for their prosecution, putting aside the underlying merits of the cases against the defendants. And this past week, we've got more of that from Letitia James. On Monday, she filed through her attorneys 22-page filing, alleging, again, the charges were the products of vindictive prosecution. Also something else. She identifies, of course, the charges against her being premised upon alleged mortgage fraud, bank fraud, as we said earlier in this broadcast. And she identifies unethical behavior, months of illegal conduct by a Fair Housing Finance Authority director named Bill Pulte, Pulte, and also another Department of Justice person, a senior presence in the Department of Justice. And, of course, he has also been a major figure in recent news. His name is Ed Martin. He was once going to be the U.S. Attorney in the District of Columbia. He's now inside the Department of Justice. He's the pardon attorney. He is also the attorney apparently assigned to figure out about the weaponization of the Department of Justice. And he has gone also focused on mortgage fraud. And according to some of the filings submitted by Letitia James, he and Mr. Pulte have engaged in a number of actions in the public domain, the private domain, that likewise suggest an animus inappropriate for the government to do. All of them recounted in these pleadings that she has now filed. Significantly, as that is happening, there is another blockbuster development also involving Mr. Pulte and Mr. Martin. And that is, it appears that internal to the Department of Justice, as to them individually, Bill Pulte and Ed Martin, there may be an investigation of them involving their pursuit of mortgage fraud allegations against Adam Schiff, and yes, also perhaps against Letitia James. An awful lot to unpack here in what would otherwise be an extraordinary breach of DOJ protocol. It may well be that Ed Martin shared some sensitive grand jury information about the James case with at least one unauthorized individual, maybe work with somebody else from outside the government to examine potential evidence in both the James and the Adam Schiff probes. Senior Trump officials inside the Department of Justice have expressed some concern that these potential instances of misconduct have compromised the investigations and arguably jeopardized the underlying cases, including the case that is now pending in Eastern Virginia against Letitia James. There is a whole lot more involving Ed Martin and Bill Pulte, who are now apparently in Maryland, an investigation being led by the FBI in Maryland, an internal FBI investigation, an internal department investigation about what they're doing, about their conduct in pursuing mortgage fraud issues, touching not just upon the Letitia James case, but also upon Adam Schiff and arguably others. Some curiosities involving a subpoena that was given to a woman named Christine Bliss. She's running for Congress in California. She shows up to a location in Maryland, presumably to testify about mortgage fraud. And in fact, she is quizzed about these other two. She's quizzed about Ed Martin and Bill Pulte. She says, it was just so strange. I asked the agents, why are you interviewing me about the people on your own team? And yes, she's confused because this is a confusing situation. Obviously, not all of it in the public record. What is in the public record reveals that the Department of Justice is going after internally the same people who prepared some of the information about mortgage fraud in support of a continuing investigation against Adam Schiff and the present criminal prosecution of Letitia James. She identifies that as well in her petitions, her arguments of just this past week, pushing back on her own prosecution. There is more there in that related case, also pending in Eastern Virginia. More to believe that government misconduct may once again be behind that case as well, in addition to the issues related to the authorization of the U.S. attorney to prosecute at all, in addition to the vindictive prosecution issue. This is a record of rampant misconduct. And again, in the Comey case, at least, we've got confirmation from magistrate judges and from district court judges of the nature of the horror that has been visited upon our criminal justice system. Across the way in Maryland, we've got the prosecution of John Bolton, and it is of a different cut. Thankfully, it is being prosecuted by career officials. And again, we don't say that thankfully because once again, every single criminal prosecution, the result of and in the midst of human tragedy. This one, however, being administered and overseen by people who know what they're doing. And indeed, as we said before, John Bolton being prosecuted for the release, the disclosure of some classified information to members of his family, based upon his time as a national security advisor. What happened just this past week? John Bolton himself doesn't appear, but his attorneys appear in a status conference in a federal district court in Maryland. That's where that case is pending. And what are the significant takeaways from that proceeding? Well, interestingly, the government says that there may in fact be more charges coming forward. They are continuing to go through a large number of documents that were covered in the case. You recall that was a part of that August search warrant in which agents of the FBI carried out materials from his home in Maryland. Material, they say, includes some classified information, and all that has to be gone through. Also raising the issue, because this is an intelligence case, unlike the Letitia James and James Comey cases. This involves classified information. This involves intelligence information. And just like the Mar-a-Lago documents case requires an awful lot of time and focus and interest and energy appropriately by the Department of Justice in figuring out how to present this in the open forum of a trial coming up. And so what happens is that the attorneys say there may be more coming up. They also say that they would like at least 6-7 months to review all of this. The U.S. District Judge who's there, his name is Theodore Chang. He appears frustrated by the length of time that this is taking and orders the prosecutors to speed it up. Move more quickly, he says. He says, I'm still having trouble with why they need 7 months to do all of this, but he recognizes that there is something complex about this case and urges, again, the government to move as expeditiously as possible, sets more proceedings down the road. Also says along the way, if you actually wanted to indict, he's addressing the government, you'd want to know what the intelligence community actually needs with these. That's basically indicating maybe you indicted prematurely before getting all of this information approved or reviewed through the intelligence community. Even so, there's also a requirement for a filter team with respect to things that may have been disclosed with respect to the attorney-client privilege. Yet that issue comes up again here, as it did presumably in the Comey case as well. And in the end, the lead prosecutor is a fellow named Thomas Sullivan, said that all this requires that the case be tried down the road. The judge does not set a trial date, but promises future proceedings. When we come back, we're going to do some rule of law snapshots as Amicus, a law review, continues here on Civic Media. This is Amicus, a law review. My name is Jim Santelle. This is the final segment of our weekend broadcast. And in the wake of our review for most of this broadcast of those now crippled, if not now fatally destroyed prosecutions against Letitia James and James Comey, we will continue to monitor in the days and weeks ahead what the judges, the magistrate judges, do in these cases. It is hugely important to follow these things because they represent not only the ways in which the Department of Justice is behaving these days in the federal courts, but also what the future of the rule of law in America is all about. When our grand jury system is compromised, when a president can dictate to the Department of Justice who will be prosecuted and presumably who will not be prosecuted, the rule of law is compromised in our nation. That has been one of the continuing themes, will be the continuing theme of this broadcast, as long as these kinds of activities continue to permeate the life and the livelihood of our nation. In other ways, this past week, the Department of Justice also much on display. Let's talk through some rule of law snapshots. Let's talk once again about James Boasberg. You remember he is the federal district judge in the District of Columbia. Way back on March 15th, he was the one who was directing that those planes that were carrying 238 migrants to El Salvador be returned. He has announced just this past week that he is going to resume his criminal contempt inquiry with respect to the Department of Justice involved in the Alien Enemies Act deportation flights. In particular, he said, I've got an obligation under the rule of law to pursue this again. He said he's interested in hearing from ex-Department of Justice officials and Department of Justice officials about who exactly way back in March and following in the administration ignored his court orders as a part of the government's very aggressive deportation effort. Judge Boasberg is back on the job after having suspended that work, not by his own volition, but by virtue of appeals and other matters going forward. Hear more about what happened in March by the Department of Justice misrepresenting the status of those migrants as they were taken to El Salvador. In another much related area, Paula Zinnes, you may recall, she is the district court judge in Maryland, now having more hearings. One hearing in particular with respect to Kilmar Abrego Garcia. You recall well, he was among the 238. The Department of Justice ultimately brings him back here, but only upon an indictment alleging illegal alien smuggling. That case is pending, a criminal case against him in Tennessee. That case is scheduled for trial in front of a district court judge in January. But in the meantime, in the immigration case, the civil case involving Paula Zinnes, she has a hearing this past week in which she explores the possibility of Mr. Abrego Garcia's removal, deportation to Costa Rica. And the government during the course of that hearing says that cannot be. We have no support for doing that. And the Costa Rican government has told us we cannot do that. That representation made to Paula Zinnes. A day later, the government of Costa Rica comes back and says that's not accurate. What the government just told you is not true. In fact, we can, in fact, be a place, a nation for the deportation of Mr. Abrego Garcia, if, in fact, that's where this immigration matter proceeds. Another instance of Department of Justice, not just missteps, but misrepresentation and undermining the rule of law system in America. Let's go back to issues related to law enforcement and military on the streets of America. Just this past week, Judge Gia Cobb, Federal District Court, in the District of Columbia, temporarily blocks the administration from maintaining more than 2,000 members of the National Guard deployed to the city's streets. She finds that the allocation, 61-page opinion, the allocation, the deployment, which began in August, was illegal for a variety of reasons, including limits on the president's authority to assert total control over the D.C. National Guard, and other concerns she identifies over the city's rights to self-governance, finds that the president's deployment of the National Guard into Washington, D.C., illegal, unconstitutional, certainly to be appealed. That happened just this past week. And then back in Chicago, once again, District Judge Sarah Ellis, we've talked a lot about her, issues what can only be called a blistering 223-page opinion in which she chronicles all of the striking details gotten mostly from body camera footage about the uses of force on the streets of Chicago during that federal immigration crackdown called Operation Midway Blitz. She recounts some of the high-profile clashes between federal agents and the protesters. She condemns them. She indicates the ways in which they have failed to follow her directives. She identifies, in particular, the 3,000 arrests in September, many of which may have been the products of illegal and unconstitutional behavior involving the use of chemical agents and tear gas and pepper balls, and in violation of her directive not to do that unless there is a need and immediate threat, which she does not find, chronicling along the way that the federal agents purposefully did not do what she was describing, describes shot flashbang grenades at the back of protesters as they fled, kicking protesters on the ground, causing a car accident during a Halloween celebration, threatening to shoot residents while pointing guns at them, shooting pepper balls at the heads of journalists and praying clergy members, tackling protesters to the ground. It goes on and on and on. This is a part of her order in connection with her preliminary injunction enjoining, stopping the government from doing these kinds of things on the streets of Chicago. It is a major decision, as are the other decisions coming out of federal district court judges around the country. We know as well that the issue of the National Guard deployment in Chicago is now before the Supreme Court. And some point, they too will be addressing this issue of military in the streets of America. We will continue to monitor that decision whenever that comes out, and all these other developments in the rule of law in America in 2025 and 2026, as Amicus, a law review, continues to come to you here on the broadcast stations of Civic Media. Have a good weekend, everybody.